weekly given away to our oppressors. Thank you.
Today, we're all going to learn a new term. It's only 2 words. Now listen closely. Can all of you say constructive fraud?
Constructive fraud!
Did you ever get the feeling as you're staring at the ceiling that this game of life we play ain't fair? Seems as fast as we can make it, there's a hand that grabs and takes it till they plant us in a grave somewhere. Like a rodent on a treadmill, we keep pushing for it uphill, but we never seem to get too far. Well, if you think you're being taken, then you're ready to awaken to the truth of what we really are. We're all indentured, servitudal slaves, overburdened and bewildered, feudal knaves. Did we fight the revolution? Did we win the world wars just to slumber into slavery? We're all indentured, servitudal slaves, overburdened and bewildered, feudal knaves, who have lost our sole posterity through ignorance and apathy, and now we're being taxed out of our graves. And as long as we stay passive, we'll succumb, contented with some humanistic crumb. Well, the naked truth and fact is we're all saps who pay those taxes, and that is why the banksters keep us dumb. While Franklin and Eleanor were telling us they hated war, they made a deal behind our backs. They said the bankers could enslave us for a portion of our wages, and today we call it income tax. But what they failed then to tell us was the way they planned to sell us into statutory slavery. Now it's called constructive fraud. Some even claim the wrath of God. I call it social insecurity. Let's stop being indentured.
If there's any government undercover agents, would you please stand up and identify yourselves? And we'll give you an opportunity here to tell us why you're here tonight. Well, it looks like we don't have any here tonight. Okay. We were able to receive a recording of a radio transmission between a police officer in Oxford, and I can't think of his name. I think it's a sergeant. Somebody help? Anybody know?
You got it right there. The tape, I just found the tape.
Malcolm. Sergeant Malcolm, and I don't know who he's speaking with, but I believe it's an officer down in Troy or in Detroit. And I'm going to attempt to play it on this little recorder and over the microphone. You'll probably be able to hear most of it, and you'll get the flavor for how these guys really think about you.
We don't know. We haven't heard anything. We thought you were going to tell us.
Nope. I talked to your partner in crime, and I gave him all the lowdown.
Yeah.
And basically, that meeting in Detroit last night was a bunch of the skinhead Wayne State University communists.
Oh, great.
Who really don't. There was no Teamster affiliation in this meeting.
So, do we know if they're going to have a meeting tonight someplace?
I guarantee you they're having a meeting, but I also guarantee you the intelligence is zip zero.
Damn.
Guys, you know where the Teamster Hall's at?
It's just up from where you guys are at there on 16, isn't it?
Negative.
Or on Mound, I mean?
One in Detroit.
Oh, no. I have no idea.
I'm trying to think of where it's at.
You think they'd be meeting down there?
Fuck yeah. You know why? I think what they're doing is they're realizing that if it's anywhere where any word gets out,
Mm-hmm.
you know, they have it at a union hall where anyone but a Teamster walks in that hall that will kick their ass and dump them in Detroit somewhere.
Oh, yeah? Now with my 37mm gun under my jacket loaded with flechettes, I'm going to whack a whole bunch of them turds. Then we start using HE loads on them.
Oh, no.
I tell you. Well, we're just going to, we're going to be out and about. If you need us, or you hear anything, call the station and they can page us, or you got my pager number there.
account?
Pager number is 807-0989. And I got my cellular and stuff, and we don't know what to do. We're just going to flop around. We're loaded up, Burnham and me, just in case, but we were really hoping to set these suckers up, man.
Well, if we hear anything, we'll dime you up, and same if you hear anything or if you're
Right.
our way.
Yeah, our guys are going to be out at 8. We're going to have one down at the point, but I doubt we didn't have any down at the point at all last night, at our strike point. Nobody showed. So I'm not sure we'll have anybody tonight if they're trying to round them up for a little tattoo there.
Right.
But where in Detroit would that Union Hall be at? Do you know?
Shit.
You know where it's at, Dominic? The Teamsters Hall?
I heard, I'm not familiar really, but I heard Hansay was right down by the riverfront plant. Right next
It's supposed to be down by the riverfront plant.
I was there. It's not by the riverfront plant. It's it's close, but it's right off of, I like to say it's right off of Gratiot or John R. One of the, it's right in the shithole of Detroit.
Oh, good. We got shotguns and all kinds of things. We got a couple squirt guns in the car.
I mean, flip over Yellow Pages or whatever, and it'll have
Yeah, okay. Hey, Gordy, get the Thompson, too. Get the Thompson. We got to go down to shithole Detroit. With both the L drums, too.
Okay.
Yeah, we're all set. Don't worry, Frank. If you hear of a bloody shootout, it's Burnham and me kind of like lost it.
no problem.
We'll see what we can dig up for you. We'll take a run down that way and see if we get, if I just find out where they're at, I'll set on them. That's all I want to do. And I got all the points, all the addresses and everything. We're all set on that. And, maybe we can let somebody know and get them trapped in there and get some damn arrests for once out of this.
Like I said, if you start following or whatever, give me a call and I'll get with Detroit PD and get their helicopter up and over it.
Right. Okay. Sounds good. And if you need us down there, give a holler, too.
Appreciate it. We'll do.
All right, Frank.
Thank you.
Yep. Bye-bye.
And he's going to be around also Saturday for a full-day seminar at the Ramshorn on Telegraph and Plymouth Road, and there'll be flyers passed out at the break. We'll take a break at 9 o'clock. He's a Dallas police officer and an investment consultant and patriot from Florida, Eddie Kahn.
I've got this. Is that going to work? That won't work. Okay. All right. This works. Thank you. I tell you what, I'm really glad to be here. I'm really glad it's not cold. I was worried about that. You guys remind me a lot of when I was up in Dallas last year. I was speaking at a group up there called Take Back Texas. And believe me, that's the way these people felt and probably still do. There was about 400 of them. And the newspaper had one of their guys there, and he wrote that they were rabid. If that gives you any idea, what they thought they were like. But I enjoy speaking to people like yourselves simply because you're doers. And that's what we are. We have developed a method in Florida, and it's kind of gone around the country now in the last 2+ years, in which if the IRS writes us a letter, or they call us on the phone, or they come by with a little personal visit, we get right on the offensive. We do not believe in being defensive at all. And as a matter of fact, it has gotten to the point now where getting a meeting with the IRS, calling a meeting ourselves and going down there to them is really, really because these guys don't want to see us, because they know that he who asks the questions in this game wins the game. And we ask the questions when we go in. And we demand the documents, and we demand them under two things. There's 609 Privacy Act notice, which is in your little 1040 booklet that you get each year with your 1040 form. It says that if you have any questions concerning the rules for filing returns and giving information, that you can visit any IRS office and get them answered. And it also says, under the Administrative Procedures Act in Title 5, 556D, it says that the proponent of the rule has the burden of proof, and that no sanction or order can be imposed until that proof is provided. It must be real and substantive. Okay? So that's what we go under. We say if you are an agency of the federal government, this does apply to you, doesn't it, Mr. Jones? you know, and right away they're starting to sweat because they don't know how to handle this. They are not trained to answer questions. They are not trained to give documents. They are trained to intimidate you and to get money from you. I mean, it's just that simple. They are there, in my estimation, to lie, cheat, and steal. And so when we come in and we're starting to demand things of them and we do it in a fashion of law, they don't know what to do. Now, just to give you an example, last year I came here, my good friend Joe Hill brought me down to speak to a group, and I told them the story that got me started in this. And I'm going to tell it to you because I think it's important for you to understand that the first time you do this, your knees shake. I mean, my knees were pounding, you know, when I went in there because we didn't know what to expect. But what happened was my research partner and myself, he's a retired doctor, we both got a summons to appear with books and records about a week apart. And so we decided that we were going to take the bull by the horns. And we were not going to be defensive, we were going to be offensive. So we called up Ms. Gibbs, who was the supervisor down at Deerfield Beach, Florida office, and we said, Ms. Gibbs, we've got some questions concerning the rules for filing returns and giving information that we need answered prior to your meeting. And she said, fine, come on down. Nobody was doing this then. And so we went to the law library over at the Florida Atlantic University, and we got all the documents that we needed that we were going to ask her about. We had 20 of them. And so we put them in a loose leaf binder. We went in to see Ms. Gibbs. And we sat down in this little room. You know, they've got these little cubicles, you know, that's barely big enough for, you know, about 3 or 4 people max. We sat down in there, and we started out with just the first question. The first question was, Ms. Gibbs, what tax is it you say we owe? And she said, well, it's the income tax, the U.S. individual income tax. Okay, now, Ms. Gibbs, what form am I required to file with that? Well, it's the 1040. We said, well, Ms. Gibbs, this is why we've got a problem with that, and we want to come down and talk to you about it. See, we always go in with the attitude, I'm just a poor old country boy and I don't know anything, and I want you to explain it to me, you know. And so anyway, we said, Ms. Gibbs, we went down to the Florida Atlantic Law Library the other day, and you can just see her start to stiffen up. And we said, we found this index here in 26 CFR in the index, and it's a 602.101 cross-reference index. And it shows here that the income tax that you say that we owe, that the form 2555 is the form you're supposed to file, not the form 1040. And we showed her the 2 forms with the OMB, the control numbers that are on each one of them, and the control number for the 2555 matched the cross-reference index with the tax she said we owed. And we said, Ms. Gibbs, you want us to file the 2555? And she jumped right up out of her behind her desk. She said, no. And then she sat down because she realized that either she's lying or that regulation's lying. And then we said, Ms. Gibbs, are you trying to get us to fill out a fraudulent form? And she had had enough at that point. She said, look, these are legal questions you're asking me and I can't answer them, and you've got to talk to district counsel and this meeting's adjourned. And she ran out of the room. Now, Ray and I were just sitting there looking at each other. You know, we didn't know what to do because we still had 19 more questions to go. And, you know, but what happened was the end of that story was we did try to speak to district counsel. You know, we want a meeting. We want to get this matter resolved. And so we both sent district counsel certified letters stating that Ms. Gibbs, stating just what Ms. Gibbs told us, that this is, you know, legal questions. She couldn't answer them. He could. You know, he's the guy. And we want a meeting. And we got his response back before we got his green card back. Now, have you ever seen the government move that fast? I never have. Anyway, basically, he said he wasn't going to do it, that you could just sue him. He wasn't going to talk to us. You know, in paraphrasing what he said. And so I got upset with that, you know, and I wrote the Secretary of the Treasury and I said, look, I said, this guy works for you. And Ms. Gibbs said, we had to talk to him. He had the answers to the questions. I want you to force him to give us a meeting. And all the Secretary of Treasury did was send the letter to the district director at Fort Lauderdale for a reply. And the district director writes us his famous Fifth Amendment letter. Of course, I'm sure you've all seen that one. He says, to answer these questions would just lead to more questions, so we can't answer those questions. That's his Fifth Amendment letter. And they use it routinely. Okay? Well, the bottom line is we keep trying. We've been trying. That was November 1993. We've been trying all that time, since that time, to get meetings. And they don't want to talk to us. Okay? And before that, in the 14 years that I did this prior, they were always after me because I was always on the defense. Now what I found out was when you're on the offense, it makes it a little tough for them to be on the offense too. And so when you're on the offense, you're winning, and when you're on the defense, you're losing. And so what we've done is we put together a little booklet. It's a how-to book. It's how we do it, okay? And it's based on our experience. It's based on a lot of other people's experiences who've now done it. And people have done it all over the country, I'll tell you. But what's really interesting, too, I was going to tell you, is that where it used to be very easy to go in and get a meeting, try to go in and get a meeting today. I'm telling you, they're trying their best to protect their agents from us, And like somebody called me the other day and told me that they went down to their office, their local IRS office, and all there was when you walked in was not a secretary, it was a bank of phones. And you had to know who you wanted to talk to before you could get in a door that had to be buzzed. Oh yes. I mean, it's really, they really get nervous because of you people like yourself, people like us, who are aggressive people, who feel that we are the masters. We're not the servants, we're the masters. But you're only a master if you act like a master. If you act like a servant, you're going to get treated like a servant, And so that's our attitude. So I'm going to show you what we did with Miss Gibbs. Let's see, Ray, you about through with that? Not through it? Okay, Joe, can you help me, please?
He's going to help you out.
Okay, all right, good. All right, we're going to show you what we showed Miss Gibbs. So you can see, we're not doing anything, yeah, we want to see the very top, Joe.
Yeah.
There you go, Joe, you got it. Okay, right over here on the left side. There you go, right there. Okay, y'all guys, y'all see that 1.1-1 right there? Can y'all see that? 1.1-1? Yeah. You might want to raise it up a little bit, Joe. Maybe they can, this part right here.
Oh, I mean,
yeah, if you go, there you go up, there you go.
It seems to lose
I know it does. Okay, can you guys see that? 1.1-1. And it's got an OMB number on it, across from it, which is on the form that's been approved for information gathering. It's 1545-0067. Okay? So that's what we showed Ms. Gibbs. And then we showed her the forms. Let's see, I think they're back over here, Joe. Yeah, right here. Ooh. Let's take this off. Dominic, can you take this, please? It doesn't work, right? It doesn't work for sure.
I won't have any sound.
Oh, I'm sorry. Oh, okay. Hold on here. Thank you. All right. Now, I don't know if you can see this very well. This is Form 2555, which says Foreign Earned Income. But you look at this OMB number on here, 1545-0067. That is the number that shows this is the form that's been approved for information gathering for the tax Ms. Gibbs says we owe. So all you guys have been filing fraudulent forms all this time, and you didn't know it. Because the 1040, Joe, if we can raise it up to look at the 1040 form. See, now here's the 1040, and look over here at this OMB number. It's 1545-0074. That's not been approved for information gathering for that tax. Okay? And that's why Ms. Gibbs ran out of the room. Because we caught her in that lie. And that's really what it is. Yes, ma'am?
In the new index, It doesn't show that one.
I know it doesn't. I know it doesn't. All they started was 1.23 now. Yeah, I know. You're going to see that this is a cat and mouse game. They got some high-priced lawyers up in Washington, D.C. that all they're paid to do is try to stay one step ahead of us finding out what they're doing. And that's just exactly what it is. As a matter of fact, just so you know, I do have a letter into the Federal Register, because they're the ones that actually make up these indexes, asking them if that 1.1-1 tax is no longer a tax. Because if it isn't, we're all in good shape. Yes?
I can't see it too well, but anyway.
I know it's a little bit fuzzy.
I don't see the expiration date. Was that a bootleg form?
No, not really. This is just a 1040 form, and it's not a bootleg form. You know, at least we've never challenged that anyway.
Title 44. You got what section of 7235, I believe, another one. So it says there are 3 requirements to make a non-bootleg form. One is the OMB number. One is an expiration date. Third is your information. Any of the 3 are absent is considered a bootleg form. U.S. versus Smith.
Right. I understand. I understand. There's a lot of ways you can get these guys. You know, what we have zeroed in on, you might say, is just the method that we use. The method that we have found that's effective for us is to simply go to their office if they challenge us. If they come in with a letter, a phone call, a visit, we want to go down there to their office and we want to find out where they got the authority to even ask us our name. You know where they got the get the authority to ask you your name? Huh? No. No. It's the reg that's canvassing the district. But when you look in the table of parallel authorities, which I'll show you in a minute, that only applies to alcohol, tobacco, and firearms agents. It doesn't apply to Internal Revenue Service. Okay.
Excuse me.
Yes.
That gentleman over there, I think, said something important. I couldn't hear all the things he said. Could you repeat it or do it louder or something? Repeat it for the
Okay. What I have said is that in Title 44, I'm not sure if it's section 7235, I believe.
This one right here.
They give you 3 requirements to make it official, otherwise the bootleg form, federal or U.S. government document. 1, you need an OMB number, that 8-digit number. Second, you need an expiration date, that is the month, the day, and the year, every 6 months. Thirdly, what you need is a information, or rather instructions to tell you whether it's voluntary or mandatory. Any of the 3 elements are not there, absence thereof, is considered a bootleg form. By law, they cannot reprise against you because it's not made for you. Title 44, excuse me, the Title 26, when they talk about the income tax, the taxpayer, Section 7701, 14, will identify taxpayer. 4 stipulations, maybe 5. 1, you have to reside in the U.S., or rather the federal government territories, enclaves. And 1, you have to be a foreign alien come to this country, U.S. citizen living abroad, and I forgot what the other stipulation was, but nonetheless, if you don't meet all those 4 or 5 requirements, you don't come under the purview of the Title 26 or 27. Do I stand correct?
Well, it doesn't matter, you know, because, the reason I say that, I'm not trying to be smart, but the reason I say that is because if you don't fill out this form, they're going to come try to get you. I mean, that's just how simple it is. So we've just developed a strategy to get on the offense, put them on the defense, where they don't want to come see us anymore, okay? And so what I was going to show you here is this is another cross-reference index. Now the cross-reference index here, it shows the statutes on the left side. On the right side, it shows what it belongs to. In other words, everything over here is either 26 or 27. You notice that? That's either Title 26, which is IRS, or Title 27, which is alcohol, tobacco, and firearms. They both used to be under Title 26. Bureau of Alcohol, Tobacco, and Firearms used to be in the Internal Revenue Service, split off in 1972. Okay, but they still operate under 26 and use the statutes that are in Title 26. Okay, now let me give you an idea. 6201 is assessment authority. Okay, that's the statute that says assessment authority. Belongs to Title 27. Okay, so that means that alcohol, tobacco, and firearms can assess a tax. Okay, it doesn't show that the Internal Revenue Service, which is Title 26, can assess a tax. Okay, now let me give you a different idea. Okay, look up here, 6154. It's Title 26, Part 1. Title 26 is IRS, but Part 1 is the individual income tax. Anything that says Part 1, that is the individual income tax. So this applies specifically and only to the income tax. Okay, 6154. Okay, this just to give you an idea. When you go through here, you're going to find a lot of those. See, here's 6654, 6655, 26 Part 1, specifically for the income tax. All right. So when you go down here, but the ones we're pointing out, assessment authority. This one down here, 6321, is lien. 6331, levy. In other words, enforcement statutes. Well, guess where they all go to? Title 27. Title 27. All the enforcement statutes go to Title 27. Okay? I'm sorry? Oh, this one down here? 7601 through 7606, that's the summons authority. Okay? And again, it's Title 27. So, basically, this is some of the things we took to Ms. Gibbs to get answered that we've not got answered today. Okay? We were going to go through all of these plus a lot more that had to do with the authority to force us to do something or say that there's a requirement that we do something. So this is how you read this thing. Anytime that that an agent says, yes, under statute so-and-so, we have the authority to do something, first thing I'm going to do is look over here and see. Okay? Now this is not law. There's no reference indexes that are law. This simply points you in the right direction to verify it in the statute and regulation itself. Okay? So this is what we use right here. And when we go down to the IRS office, well, we don't really start out with this anymore. We've got something better to start out with now. And I'm going to show you that. You know, they continually try to keep us from doing what we do. And we continually come up with different ways of doing it. You know, because we're not going to stop. Okay, let me see here. I'm going to show you what we're talking about. Now let's see here. I thought I had, oh yeah, here we go. Okay, let's start out with this letter right here, Ray. And then we'll go to this letter and then this. Yes?
Where did that table parallel authority come?
That comes from the Code of Federal Regulations Index. It's the last book of the Code of Federal Regulations. Yes, Joe?
And I think for the benefit of the audience, you might explain that there are 50 titles in the United States Code, and for each title there's a corresponding book of regulations. So if you have Title 26 is the Internal Revenue Code, you'll also have Title 26 Code of Federal Regulations. They sort of match up with each other. The statutes are sort of the general and permanent law of the United States, and the regulations basically are the specifics of the law. And so when he shows you that the taxes are in Title 26, there's a multitude of taxes in there, and you go to the regulations and you find the regulations are in Title 27, you know that deals with, well, Title 27 is intoxicating liquors, or alcohol, tobacco, firearms, and explosive matters. If it were Title 5, it would be something else. But when it's 26 and 26, you know that they're talking about an Internal Revenue Code tax, or maybe you go on about that.
Right, exactly. Yes, sir?
I wanted to ask a similar question along the lines. When you're dealing with Title 27, you're dealing with excise or privilege, and you're also realizing that Title 27 has criminal penalties. Title 26 is civil and is going after civil authorities. Now they have convoluted the two and they have cross-mixed them. It's important to pay attention whether you're in Title 27 or Title 26 to find out if there's excise or privilege tax. I mean, if you're not in business selling alcohol, tobacco, and firearms, you don't belong in 27. So how could you be an excise?
I understand. Okay, did everybody hear that? Basically, under alcohol, tobacco, and firearms, that's privilege taxes. In other words, you're going to get a license to sell, distribute, or manufacture alcohol, tobacco, or firearms, basically. And you get a license for that, okay? And so they get to have you pay for your privilege of getting that license. But in the income tax, there is no such thing. That's why that you'll find that the one is 100% voluntary tax. According to Dwight Avis, who was the head of alcohol, tobacco, and firearms back in 1953, he, in sworn testimony before the House Ways and Means Committee, he said that the income tax is 100% voluntary tax, and the alcohol tax, as an example, was 100% enforced. And that's the reason why. Okay? Now I'm going to show you a letter. This is a letter that we sent to the Federal Register, because it says here, has the Internal Revenue Service incorporated by reference in the Federal Register a requirement to make an income tax return? This is what we do to them nowadays, okay? This is how we start with them nowadays. We asked, is there a requirement to make an income tax return? Okay, Ray, go ahead and show them the next one. This is the letter we got back from Michael White, who is an attorney there at the Federal Register. Okay, we'll need to see this bottom part down here. There you go. Okay, here's what he said in his reply. He says, our records indicate that the Internal Revenue Service has not incorporated by reference in the Federal Register a requirement to make an income tax return. Now, I bet all you guys thought it was mandatory, didn't you? And he says, there is no requirement in the Federal Register to make an income tax return. Now, does it matter if it's in the Federal Register or not? Yes, it does. Because everything that's applicable to the general public that's a requirement has to be there. Okay? If it's not there, then it is not applicable. Okay, yeah, go ahead and show them that one, Ray. So we looked up their regulation on the subject. It's 601.702. All right? And this is in 26 CFR that Joe was mentioning. It says, effect of failure to publish, okay, in the Federal Register. If you go down here to this last sentence, it says, thus, for example, any such matter which imposes an obligation and which is not so published or incorporated by reference will not adversely change or affect a person's rights. So their own regulation says it has to be there, doesn't it? Okay? So when we go down to the IRS office, we go down there and we say, I've got one question. Is there a requirement to file an income tax return? And of course, we already got all the answers, right? And so he's going to say yes, because if he said no, you'd say thank you. You know, I don't want to do this. And he's going to say yes, and he's going to say Section 6012 of the Code says if you make more than the exemption amount, that you have to file a return. Now, most people are going to stop right there. They're going to say, oh, there is a requirement. Okay, 6012 of the Code. But that's not far enough, folks. Okay? They say themselves that if they don't publish that requirement in the Federal Register, then it can't adversely affect you, so it has to be there. Okay? You need the statute, you need the implementing regulations of the statute, and you need the page in the Federal Register that shows there is a requirement, that it has been published. Okay? 3 things that you need. Just a minute, sir. If you guys can kind of hold your questions till we get through this, we're going to have a question and answer session toward the end, but I'm afraid we're going to get caught off on too many tracks here if we keep going this way. So this is what we ask him. Is there a requirement? He's going to say yes. 6012 of the Code says, yes, it must do it. Well, this is why I'm confused. And this is why I'm here talking to you, Mr. Expert, because I want you to answer this for me. I've got this letter here from Michael White, who is an attorney at the Federal Register, and he said there is no requirement for filing an income tax return listed in the Federal Register. So I looked up your regulation on the subject, and it says that if it's an obligation, it has to be there. And I couldn't find it. Michael White couldn't find it, so why don't you go get me a copy of it? And you never seen such scurrying in your life, because these guys don't know what to do. You know, they just saw in their own regulations that if it's an obligation on their part to do it, it has to be in the Federal Register. Okay? So they have to go get it. Well, what they usually do is they'll leave the room for a while, and when they come back they're abusive because they went and talked to their supervisor, and the supervisor says, go in there and bully them, you know. And so they come back and they try to be abusive. But we're ready for this because we never try to spend more than 5 minutes with either the agent or the agent supervisor, because we found out that neither one of them have the authority to lift a lien or to lift a levy or to quash a summons. So what good are they to us? Not much. You know, so we're wanting to get up there to where somebody's got some authority. It's just like when you go and try to take something back to a store and you go to the customer service and she says, I'm sorry, we can't take that back. You know, do you stop there? Shoot, no. Where's the manager? You know, well, same thing. You know, that's exactly what we do here. We're ready to go upstairs. As soon as they say no one time, we're out of there. Okay? Mr. Jones, you just denied me due process of law under the Administrative Procedures Act. The proponent of the rule has the burden of proof. You're the proponent of the rule. You got the burden of proof. And you say you're not going to show it to me, right? Okay, who's your supervisor? I'm filing a complaint on you. Okay? And that's what you do. You don't waste time. I've had people come back and tell me, Eddie, I went down there. I had a great time. I spent an hour and a half with this guy and just beat him up. And I said, well, what good did it do? You know, I mean, you had a great time, but what did you accomplish? You're supposed to go down there with the intention of getting him to say no to something so that you could get on up the ladder. We call it walking the ladder. We want to get up to group leader or higher. If we can do it on the first visit, that's great, but we want to at least get to the supervisor on the first visit, because we realize that neither one of those people can help us. But we got to get to somebody who can. But we want to develop a conspiracy here, okay? A conspiracy to deny us due process of law. And every time they say no to you, that we're going to go ahead and we're going to collect, but no, we're not going to show you the page in the Federal Register that shows we have the authority to do it. Well, wait a minute, that doesn't compute, see? So this is what we're doing. We're building up a case, a criminal case against these people, because we fully intend to file criminal charges. See, most people don't think you can file criminal charges against these people. We have done it. I've got 4. I've got an affidavit of probable cause packet that has 4 cases that were filed in the last year and a half, all of them successful. Okay, now when I say successful, none of these people went to jail. Okay, but what happened was, in 3 of the instances, people had property that had already been taken when they filed these criminal, it's actually called an affidavit of probable cause for a criminal complaint, and that property was returned in 10 days or less. One guy got his back the next day. Okay? There was another lady that also they had filed criminal charges on her. Those criminal charges were dropped in 10 days. Okay? So if you don't think there's some pressure here, you're wrong. Because we've got them. You know, I mean, I've got the documents that were used, and 2 of these people I know personally. You know, in fact, one guy from Okeechobee, Florida, just to let you know what happened to him, he had a car that they came and took out of his carport one Monday morning. Okay? 3 Okeechobee deputy sheriffs, the tow truck driver, and this little lady IRS agent all came to his door early one morning before he left for work. And the deputy says, don't touch the car, John, we're taking it. Okeechobee's not a big town. Okay? And so they took his car. They just hauled it off. Okay? John came down to see me on Tuesday. I live down in just about 80 miles from him. He came down to see me on Tuesday, and I showed him how to fill out one of these things, these affidavit of probable causes. And he filed it on Thursday with the county sheriff. And so that afternoon he got a call from the IRS. And the agent said, well, you know what, we were planning on selling your car at auction for a $900 minimum bid. Now he owns a BMW, you know, and it's a $900 minimum bid. And but if you want to go ahead and pay us that $900, we'll just give you your car right now. You won't have to go through it. And John says, well, he says, I'll do that. He says, because I need the car. But he said, the criminal complaint stays in place because now you're stealing my money rather than my car. And he said, I'll be down there to pick it up Friday, you know, the next day. Well, the next day they called him. And they said, well, we think this is going to be more trouble than it's worth. So you want us to haul that car back over to you, or you won't come pick it up? He said, I'll come pick it up.
No, bring it to me.
No, he didn't want to mess with his car. That's right. That's right. So he goes over and picks it up. Now, let me tell you the kicker to the story. Monday, the next Monday, the sheriff calls him. And the sheriff says, John, would you consider taking my 3 deputies off your criminal complaint? Because who stole the car?
The deputy.
The deputy stole the car. The little old IRS agent was just standing there. And these big bad deputies go up there and take the car. Was there a court order? Was there a warrant? Was there a judgment? No. There wasn't any process of law. And under Article 9 of the Florida Constitution, it says you can't be deprived of property without due process of law. Every state constitution has that. Okay? So John had just quoted in there, hey, they took the car. There was no court order. Where's the due process? You know? So basically what the sheriff was looking at was filing the criminal charges against his own deputies, you know, and the county prosecutor having to prosecute them. Was not a good sight. So John said, I'll come down and talk to you about it. So he went down and talked to him, and the county prosecutor was there in the sheriff's office when he got there. And so they sat down to talk. And John says, you know, he says, the reason I filed it against you guys is because you took the car. You know, the little old lady didn't take the car. You took it. And the sheriff said, well, John, you know, I mean, we have to. He says, why? He says, was there a court order? And the sheriff said, well, he says, you know what, we've always assumed they had a court order. We've never asked them. Now, that's what the sheriff said. And John says, no, they never have a court order. You know, they just come down and give you this little notice of levy, and you just go do it. You just go steal for them. And the sheriff was sitting there, and he was getting hot. And he says, you know what? He says, doggone, we have never asked these people this. You know, we just always assumed we had to do it. And he says, never again in Okeechobee is this going to happen. He said, if they don't have a court order, they ain't getting nothing from us.
All right.
That's right. We educated one sheriff. That's right. That's the way we do it. You know, a step at a time. That's the way this thing works.
What happened with the deputy?
He took them off. He took the deputies off. John told me later, he said, look, this is a small town. He says, I want to be on good. He says, matter of fact, the sheriff calls me by my first name all the time now. He's just so happy. You know, I mean, he said, I'm sure that if anything, if I call and say, Sheriff, I need some help out here, I'll have it, you know, just real quick. You know, so he was, and he took the tow truck driver. See, he had the tow truck driver on there too. He took them off, but the agent, the lady agent, and her supervisor was also on there. Now, he got the supervisor on there because he called the supervisor up and he said, did you authorize this lady to come out here and take this car? She said, I sure did. Good. Just put it right down on there, you know. And so they were still on there. Now, nothing has happened in the way of, you know, criminal action on this thing since John hasn't pushed it. In fact, I haven't talked to John now in about 3 months. But I know that John told me at the time he wasn't pushing it. For whatever reason, he just wasn't pushing it. But the fact was, he had them in a bind, didn't he? He had them in a bind. I mean, they were sitting there begging, you know, because he had it registered as an affidavit of probable cause, and it had sufficient evidence, you know, on the fact that there was no probable cause for them to come out there and take it. I mean, there was no court order. No warrant, no judgment, no due process there at all. And under Florida Constitution. See, that's how simple it is. You don't have to. Some of the best things I've ever seen legally were a page or two. You know, I've seen 30 and 40, 50-page documents that I got tired of reading, and I'm sure most everybody else does too, that tries to go through them. And but I've got another thing I'm going to show you here that we've also done in bankruptcy court. That was 2 pages, and boy, it just set the judge on edge. You know, it was 2 pages, you know. So anyway, just so you understand, guys, this is some of the things that you can do. You know, I mean, you are not without weapons. Believe me. What we try to do and what we like to do is use state law, because where you live is in the state. You don't live on a federal enclave. You know, most of you don't anyway. And so that federal law just doesn't apply to you. Most people, including law enforcement officers, think it does. But it doesn't. Okay. Now I'm going to show you an example here of how important implementing regulations are. Okay. Now, this is a case called California Bankers versus Schultz. Yeah. Okay. You guys familiar with that? Okay. This is talking about the importance of regulations. This is a Supreme Court case, and it says right here. It says the Act's penalties attaching only upon violation of the regulations. That's pretty important, isn't it? Without the regulations, it also says that the Act itself would do nothing. You know, it has to have the regs. Now, let me tell you how important the regulations are. You know, people go to jail every year for violating this. This is where you fail to, to fill out that little CTR form 4789 when you withdraw or deposit more than $10,000 in the bank. Okay, people go to jail for that every year, don't they? Every year. Well, I'm going to show you what the regulations say about this. And if people knew to look at the regulations, nobody would go to jail on it. Let's see, I think it's this. Oh, let's see, let's go over one. Yeah, right here. Okay, let's look and see what the regulations have to say about this. Now, this is still the same court case. It says, under the implementing regulations, only financial institutions must file reports with the Internal Revenue Service, and then only where the transaction involves the deposit, withdrawal, exchange, or the payment of currency exceeding $10,000. Okay? Do you know how many lawyers look at the implementing regulations on anything whenever they defend you? Hardly ever. As a matter of fact, I've got a friend of mine who's an attorney, and when I first did this book, I gave it to him to look, and I said, punch holes in it, Randy. Whatever you can find is wrong, please do it, you know. And Randy kept it for a couple of days, and I said, Randy, I said, what did you find, what'd you find, what's wrong with it? He said, well, I couldn't find anything, Eddie, but he says, I know it's wrong. I said, really? I said, what's wrong? He said, I don't know, but this can't be right. He says, you're talking about a massive scheme here. I said, well, Randy, I said, just point out where it's wrong, So anyway, Randy was so insistent that it was wrong and that the regulations didn't mean all that and they didn't say all that, that he called me up at 11 o'clock one night, says, we're going to my library, which is the county library in Delray Beach. It's only for attorneys, okay? Only attorneys can go there. He said, I'm going to show you. Okay, so 11 o'clock at night, he comes by and picks me up. We go down there, and we go in, and the first thing that we see is that there is no Code of Federal Regulations for the feds there at all. Now, can you imagine that? You go to any teaching library, any college library that teaches law, they have the CFRs right along with the statutes. But this is for practicing attorneys here. This library was only for practicing attorneys. No Code of Federal Regulations. Now, I did have the Florida statute and the Florida regs, but no feds. Yeah, now isn't that interesting? He was totally shocked. I said, Randy, I said, when have you ever looked for regulations? Well, never, but still. He was just dumbfounded. But see, you can see how important it is. If you looked at the regulations, you'd see right away. We'll say the feds had charged you with this. This is a criminal offense. You go to jail for it. And if they charged you with this, and you went in and looked, says, well, wait a minute. The implementing regulations say it only applies to financial institutions. Doesn't apply to me. What's the form? 4789. Okay? Then you're off the hook. That's it. It's done. It's over. Right there. Okay?
The case number on that?
On this, there's a case number on it. Let's see. Yeah, it's California Bankers Association versus Schultz. Look back on
16 U.S. 21 is right up there.
416 U.S. Okay, right. Okay.
At 22 is where you're going to find it.
Okay. Did you get that? It's right. It's right here.
16 U.S. at 22.
Right.
Okay, right there.
Right there. 416 U.S. at 22.
Now, I've got another case where somebody was also being tried on this same charge. Okay? And he was fortunate enough to understand what the regs were. Right here, U.S. versus Rennes. Let's do this one. You can just leave those over there on the side, Ray, if you want to. Don't worry about putting them back in the book. Just Okay. This is U.S. versus Rennes. Okay? And my research partner just wrote this in here. Failure to publish Form 4789 in Federal Register fatal to the government. Okay? Currency transaction report. Now, why didn't they publish that in the Federal Register? I'll tell you why. Because it doesn't apply to the general public. See, remember what I told you? If you look in Title 44, Sections 1505, 6, and 7, you'll see that they must publish any requirement of the general public in the Federal Register. But they do not have to publish anything in the Federal Register that does not apply to the general public. Okay, this applied to who? Financial institutions. All the financial institutions get a license from the government, don't they? So they all got notice. And because they all got notice, they weren't required. Yes?
The Federal Register is for a living human being, and for all others, you don't have to register. Innate objects. That's a simplification, but that's the way I'm beginning to understand what you're saying.
Well, it's not quite right, because if it applies to federal government employees, they don't have to publish it either. Because, see, all those will get notice. Yeah. Well, anyway.
They're leeches to
me. Anyway. Okay, now see what the court said right here. It says currency transaction reporting form providing that multiple transactions by or for any person which in one day total more than $10,000 should be treated as a single transaction if financial institution is aware of them, was not effective as a regulation under the Reporting Act where such form was never promulgated. Promulgated means published in the Federal Register pursuant to the rulemaking requirement of the Administrative Procedures Act. Okay? It's not applicable to the general public. That's why they don't publish it. That's why you always want to make sure. Remember what I told you when we go in and we say, is there a requirement for filing an income tax return? And it's not in the Federal Register? Now what does that tell you? It tells you it's not applicable to the general public, isn't it? Or else it would be in the Federal Register. It has to be.
Haven't they lowered that amount from 10,000 down to 5 or 4 or something?
Actually, when you go into AAA to get traveler's checks, they say 3,000. But we're fixing to sue AAA because, you know, that's one way that you can get these guys' attention. We're going to notice them that Form 4789 only applies to financial institutions. And we're going to show them the law and the regs, and if they don't take that sign down, they are in big trouble. Okay?
Class action lawsuit?
Well, you could, but we're going to make it simple, you know. But this is something that you can do. You know, anybody can do that. You notice them that they're wrong, okay? That what they're saying that you are required to do, you're not required to do, and if they don't change it, then they've been properly noticed. Then it's Katie bar at the door, okay? And I really think that this is the way. By the way, Joe, that was the other one I was thinking about. Yeah. See, we're looking at also going after H&R Block. Okay, because instead of going after the government, let's go in the back door, you know. Let's get one of these big boys that says, oh yeah, you got to file that 1040 form. Really? Okay, show me where. Let's notice them, and then let's hit them, you know.
I was thinking about going to the H&R Block school and letting them teach me the wrong way. And then suing them.
Teaching you to break the law.
Yeah.
Yeah, well, can you see how this works, guys? They can show you a statute and implementing regulation sometimes, but then when you say, well, let's see the page in the Federal Register that shows that requirement applies to the general public, they go, oh. You know, because that's that third step that only applies to the general public. Okay? Let's see it. They got to produce it under the Administrative Procedures Act. They don't have any choice. They're the proponent of the rule. They got the burden of proof. Okay, yeah, let's look at this one right here. I'm going to show you guys another case. I'm telling you, this is so good. I really like this case here. It's United States versus Ernest Sims. Okay? And it's 355 Fed Sub 514. Now, it's U.S. versus Ernest Sims, and it's 355 Fed Sub 514. Now, the real interesting thing about this case here, this was a Bureau of Alcohol, Tobacco, and Firearms case. And they took this guy's car, or truck, I think it was, under the forfeiture, okay? It was under a forfeiture. And he fought it. They went to court, and the court ruled, yeah, they can take it. Okay, BATF can take it. And then what he did was he says, well, wait a minute. Look at this little section right here. This is 26 Code of Federal Regulations. No, not regulation, I'm sorry. 26 USC 7401, which is authorization. And it says, no civil action for the collection or recovery of taxes or of any fine, penalty, or forfeiture shall be commenced unless the Secretary or his delegate authorizes or sanctions the proceeding and the Attorney General or his delegate directs that the action be commenced. He said they didn't do that. They never evidenced the authorization from the Secretary or from the Attorney General. And now that you have to remember, this case was already done. This is the done case. It's over. Okay, now look what the court said. Let's go over here, Ray, where we can look at this side right here. Okay? Now look here, 1 and 2. This court finds no rational means to avoid the conclusion that the requirement of 26 U.S.C. 7401 are jurisdictional. United States District Court, being an Article III court, engendered in the discretion of Congress, has generally such subject matter jurisdictions the Congress shall establish upon the conditions as the Congress may impose. And this is one of the conditions they imposed. Thus, where Congress prohibits the commencement of a civil action unless certain specific acts are performed, this court has no jurisdiction over the subject matter until the requisite conditions are met in fact, and such compliance is shown by the pleadings and, where necessary, established by proof. Okay? Now, is that strong enough? That's pretty doggone strong, I think. Okay? In other words, it has to be there. Taxes, penalties, fines, forfeitures. Everything they do to us, this has to be there. Okay? All right. Now, let's run right down here to the bottom one. Okay? This is the final thing on what the court said. This court holds that 26 U.S.C. 7401 requirements constitute facts essential to jurisdiction. The failure to prove jurisdictional facts when specifically denied, in other words, if he hadn't denied it, would it have mattered? No, his car's gone. See, it's gone. But he did deny it. Is fatal to the maintenance of this action. This court erred in hearing the case. Now, you don't see courts saying that too much. On the merits, and now determines that the hearing was a nullity and not amenable to effective order or judgment, except the order now made that this court does not have jurisdiction over the subject matter. So any time that you're dealing with the Internal Revenue Service and they're trying to collect taxes, penalties, fines, or forfeitures, 7401 is the one thing that you want to talk about. Okay? Where did the Secretary, where's that paper where he delegated this to his subordinates, and where did the Attorney General delegate? Okay? Let's see those delegations.
That's the Secretary of Treasury.
The Secretary of the Treasury. Uh-huh. This is just a district court case, right? I'm sorry? Let's see, what district was that from right here? Eastern District of Kentucky, right?
Would they have to delegate that authority on each time that they did that act?
Every time.
Every time. So they couldn't make it a blanket thing that all my agents can go out there and do this. It has to be specific to the charge.
Absolutely. To this specific instance.
Okay.
Every time. Absolutely. Huh? Just like a warrant. Exactly. Yes. Each individual time. I'm sorry?
What would be the government's penalty for having pulled that on them?
Well, it depends on what you do to them. See, most people are so happy to get out from under them, they just, hey, I'm free, you know. Instead of figuring out, now, these guys cause me a lot of pain, now how am I going to get it back? You know, how am I going to get compensated for this? You can do it two ways. Well, you can do it several ways. One of them is you can file criminal charges against them. Okay? These people are presumed to know the law, especially the attorneys, and you can file criminal charges against them. You know, what we have found that's really good about criminal charges is that usually nobody goes to jail, but they usually want to do something good for you, you know. You know, so we find that that's real good. And it's also quick. See, if you sue them, you're going to sue them in their court as a rule. And that's usually not very good because it's a stacked deck. Okay? But now you can get them in common law court nowadays do a commercial lien and then have it adjudicated in common law courts. And they're doing that in Texas with success. In fact, I have a court case from where WFAA TV and Bellow Corporation in Dallas, Texas was filed on a $1 billion commercial lien, and it was done in a common law court. It was adjudicated. Bellow didn't show up, at the hearing. And then these people who got the lien, they started to possess, They started to possess WFAA TV and Bellow Corporation assets. And so Bellow Corporation runs into federal district court there in Dallas and says, we need declaratory relief, here. We need injunctive relief because these people are taking our assets. And Jerry Wilkins, who was one of the guys that did this, he happened to be an attorney. This was a patriot group, just to give you a little background on it, that WFAA did an expose on without their knowledge and consent. Okay, that's why they filed the lien on them. And Jerry Wilkins was an attorney, but he's also a patriot, and he filed the brief in opposition to the injunctive relief. And basically what he told the judge was real simple. He says, look, the 7th Amendment to the Constitution says that in any controversy over $20, we have a right to trial by jury of common law, of your peers, and that once the judgment's been reached, that it can't be reheard in any other court in the United States of America except under common law rules. And the judge, in one paragraph, one sentence actually, says it's res judicata and I can't hear it and that's it. That's what the federal judge says. Yes, sir?
The state employees elected or hired, do they have to pay federal income tax?
Hold that question. We're going to get to those questions and answers. Just hang in there.
Okay. Now, do you guys understand what I'm? If you got any questions, just write them down because we will have an opportunity here to answer your questions for you. But what I'm trying to do here is to show you. Oh yeah, we'll go ahead and do this bankruptcy thing right now. Oh no, let's do this first. Let's do this first. You can't tell I like this. I tell you, I really hate doing this because my wife hates it when I leave. Because she has to handle all the business that we do. We have a home-based business, and she has to handle all that, and we homeschool our children, so she's got to handle all that, and but I do enjoy this. I have to admit, I do kind of enjoy this. Okay, now, this here is still on those CTRs. Now, CTR, again, is that 4789 form that you have to fill out if you do more than 10,000 withdrawal or deposit in a day. Let's look at this right here. It says, if the BSA and the Treasury Department regulations do not clearly compel the filing of CTRs under a particular set of facts, it cannot be unlawful under a more general statute not to file them. So what is he telling you right there? The regs are specific, aren't they? You understand, just like you did understand. See, you didn't know by looking at the statute who it applied to. It looks like it applies to everybody. But you look at the regulation, it says it applies to financial institutions only. Now that's pretty specific, isn't it? Okay? So if anybody ever says to you, yeah, you just violated statute so-and-so, what's the first thing you want to do, whether it's state or federal? Go look at the regulation and see if it really does apply to you. Okay? Because most of the time you're going to be shocked to find out that it doesn't. Okay? And this is exactly what they're saying here. The regulations compel. That's why you can only violate regulations. You can't violate statutes because they're general. Okay? Okay, now raise this up right here. Okay, I want you to look at this. Now, this is that California bankers case again. Okay, and it says, this is what the court says. We think it important to note that the Act's civil and criminal penalties attach only upon violation of regulations. Promulgated, which means published, by the Secretary. If the Secretary were to do nothing, the Act itself would impose no penalties on anyone. That's pretty strong stuff. Okay? Now, I want you to look right down here. Can you see this right here? United States versus Oliver L. North. Now, you guys remember Oliver L. North? Yes? Okay, now Oliver North, in his little Iran scam, he was charged with this crime because he deposited a lot of money and withdrew lots of money, and he didn't fill that $10,000 thing out at all, okay? And so he was charged with this. Well, you know what happened in his case? His attorney went up to the judge and says, Judge, there's been no implementing regulation here that says that my client would have to require that, or would have to file that. And that's only for financial institutions. And the judge says, golly, bum, you're right. You know, case dismissed. You know, and that's how fast it happens when you look at the procedure and see that you know, this is just procedures, all it is. Okay? The procedure is they're going to try to hit you on the statute and hope you never think about implementing regulations. That's what they do. Now, how many of you people normally will look for regulations when you're talking law? Not a whole lot, you know. But I'll tell you, you better start looking at it, because you're going to find yourself in a lot better position. Once you start doing this, you're going to find yourself in a lot better position. Okay, now let's go ahead and look at that other one. This one here, this is that bankruptcy case I was telling you about. This is a Dr. Dumont that's up in Ohio, and the IRS was after him. They hit him with a $120,000 lien. As soon as they did, the bank who was financing some of his property, they filed a foreclosure on it, you know, to protect their interest in it. And so he went from a Chapter 13 to a Chapter 7. When I was talking to him, he was crying on the phone to me, you know, and I said, well, Doc, I said, if you ever, you know, they don't have a valid claim against you, a valid lien. Did you ever file any motions to dismiss their claim? He said, how do you do that? And so I wrote this up for him. Okay, now you can see it's pretty short. Go ahead and raise it up some, Ray. See, this is it. Okay, that was it. Okay, we said that the IRS made an insufficient claim. They did not evidence the statute and the statute's implementing regulations that required respondent to file a 1040 form, that required respondent to pay a specific tax, that gives the IRS the authority to collect the tax, that gives the IRS the authority to assess the tax. Okay, and then we really hit them with the killer, and this is, respondents have a copy of their individual master files specific for each of the years in question. They were obtained under the Freedom of Information Act. Respondents are coded on their IMFs for the years in question as MFR01. According to the Internal Revenue 6209 manual, which is used to decode the IMF, the MFR01 designation means we are not persons required to file or mail a tax return. Okay? Now, since he's not required to file or mail a tax return, how could he possibly owe any money? Well, what happened was the IRS agents went in and did a substitute for return for him. And they filed one for him, since he didn't file one himself. And they said, based on our, you know, what we've got here, you owe us $120,000. Okay? So, anyway, we filed this along with an affidavit in support of it, and the affidavit basically looked like this, except he was, you know, it just had the heading for the affidavits. And he gave them each of the individual master files for the years in question, which showed he was designated MFR01, and sent that in. Now, so you have to remember, he had an attorney when he started, but he ran out of money. The attorney didn't stay around once he ran out of money. So Dr. Dumont had to file this himself. And he didn't even know to even notice the U.S. attorney, and he didn't, you know, which is a procedural error. Okay, well, the judge didn't care. When the judge got this thing, he immediately says, we're going to have a hearing in 30 days. Okay? And then he noticed everybody and his dog from Janet Reno on down. I mean, he was nervous, you know, because he could see a big buck lawsuit here, you know, and he's not wrong. You know, I mean, this guy's pretty smart. And anyway, the bottom line was they ended up releasing his property. The IRS released the lien, you know, on the property. But it's not over, because his wife died as a result of all this IRS harassment, heart attack, and he's been in and out of the hospital. He's a frail, older gentleman. Matter of fact, he was here last year, Joe, Dr. Dumont. You know, if he can hang in there, he's going to have a lot of money coming, because we're fixing to get him, you know, and I just hope he can handle it. I hope he can hang. But this is, you know, this is how simple it is to file motion. Now, we've got, since this time, we've learned a lot more about the bankruptcy, and there's so many ways you can beat these guys in bankruptcy, it's not even funny. And I really like bankruptcy, I'll tell you, because we use it as a weapon. We do not use it as a defense mechanism. You go to any attorney, and they're usually telling you, well, you can take off the last 3 years, you know, of, you know, what you owe them. but then it's going to be 7 years before you can use it again, right? Well, we don't go that route. You know, we go in there and we're saying, look, we're filing a motion to dismiss your claim because it's insufficient for this, you know, and then we're going to get it kicked out. Now, once we get it kicked out, then we're going to file a lawsuit against them, because I've got court cases which say that if a government agency files a claim against you, they consent to be sued. They lose all sovereign immunity. Okay? So, who's got the deepest pockets? They do, you know, and boy, we're going to clean them out.
That would include right up to Reno with the fact that the federal government, because she's a rep of it.
Sure, sure, absolutely. But y'all see how easy this is? Okay? Now, I'm going to show you before we leave here how you can be an MFR01 too. Okay? Now, an MFR01 designation means that you're not required to file a mail a tax return. Okay? Some of you people might like to do that. I don't know.
What do you have to give up?
This is going to be in the 5th update to the book, but I'm going to show you tonight, you know, how it's done, you know, so you can do it. What we've got in the book, just so you know, is we got a lot of the documents that we use and the procedure that we use when we deal with the IRS. Okay, it's really a matter of attitude. It's like I had a guy tell me the other day. He says, Eddie, he says, I've always been aggressive against these guys, but now he says, now I'm aggressive with knowledge. He says, it's so much better, you know, because he really knows what he's doing. He usually just go in there and he's just mad. And now he knows what he's doing. And 4 minutes? Okay. All right, we got 4 minutes here, guys, before we take a break, so let's see what we're going to look at next here. Huh? Yeah, go right to the chase, huh? Okay, no, we'll look at this here. We'll get to the MFR after the break. We'll spend some time with that. Okay, this is that affidavit of probable cause I was telling you about. Now, this is John Ellis up in Okeechobee. This is his. This is, you know, remember I told you they got his car on Monday. He came down to see me on Tuesday. And this is how simple it is. This here, the total thing was like 2 pages and about that much, and double spaced. You know, you just don't have to do a lot of stuff in here. You just tell them what they did that was wrong and who did it, and that you want them arrested. You know, and that's really it. See, this is just how he did it. Okay, so just understand we've got 4 of these. We got 2 of them that were filed with the county sheriffs. We got 2 of them that were filed with the U.S. attorneys. And in every case, they were successful in getting relief. Okay? So when people tell you you can't do something, you know, I'm here to tell you this, you can do this. All right? So, okay, it's about time for us to take a break. How long are we going to take a break for? 15 minutes? Okay, 15 minutes, guys. We'll come back, and then I'll show you how to get classified as an MFR01. Hello? Okay, one thing that somebody asked me during the break, which is a good point, I want to bring it up, is don't take, any of you people that brought this information, don't take my word for it. Go to the law library. Ask the librarian there to help you find those documents. Those documents are there. Find them. Once you find them, you become very strong, because then if you ever have to talk to the IRS, you say, look, I went to the law library, I looked them up, and this is what I found. Okay? If you take somebody else's word for it, you're kind of like building a house on sand, you know, don't do that. Okay? Now I'm going to show you, most people think that federal law applies everywhere, and that federal law is superior to state law, and that's just the way it is. And I mean, most law enforcement officials are that way. But I want you to look at this right here. It says the federal government can make any laws they want to concerning land over which they have exclusive jurisdiction. The laws do not have to be constitutional. Now, every time that Congress makes a law, and we say, that's not constitutional, how do they get away with that? Well, what's that law for? That law is for the area in which they have exclusive jurisdiction. How do you know that? Because it's not constitutional. That's how you know it. Okay, it's real simple. Look at this case right here, Kahn versus U.S. It says the laws of Congress in respect to those matters outside of constitutionally delegated powers do not extend into the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. It's 152 U.S. 211. Now that's pretty plain, isn't it?
There they are.
That's pretty plain. You know there's about 600 cases like this? This has been litigated to death. And the courts have ruled consistently. As a matter of fact, just this last year, I've got 2 cases, 1995. One of them is United States versus George Wilson et al. As a matter of fact, let's go ahead and, well, let me go through this here and then I'll show you the recent cases, okay? See, these other cases, Downs versus Bidwell, and New Orleans versus United States, Foley Brothers, they're all the same, you know. It is well-established principle of law. All federal legislation applies only within the territorial jurisdiction of the United States, unless a contrary intent appears. That's all it applies to. And so there's many, many cases like that. So you have to understand one thing. Every time you see a law that's unconstitutional, where does it apply? Yes, it does. It applies in Washington, D.C., the enclaves in the territories, because they can make any law they want to there. You know what they are there? You know, we're supposed to be a Republican form of government in the states. What are they? A democracy. They're a democracy. They tell you that all the time. They're a democracy. And you keep saying to yourself, well, wait a minute, we're not a democracy. What is he talking about? Washington, D.C. is a democracy, because that's the type of government they decided to have there. If they decided tomorrow that Bill Clinton should be king, they can be that. And I think he's already done that, hasn't he? But, you know, they can be anything they want to. Why? Because, let's pull that down a minute, Ray, and I'll show them. Okay? It says exclusive jurisdiction. Now, exclusive means just that. Exclusive. They have sole authority. Sole authority there. They can do whatever they want to. So understand that, and you're going to be way ahead of most people. Okay? Understand it. You'll be way ahead of most people. Their exclusive jurisdictional area, they can make any law they want to. So anytime they make an unconstitutional law, you know right away it doesn't apply to here, because it says outside of constitutionally delegated powers. See? If they make a law that's constitutional, then it can apply to the 50 states. Okay? Okay, now let's go on up here, Ray. It says here, administrative agencies must prove they have jurisdiction. Jurisdiction is essential to give validity to the determinations of administrative agencies, and where jurisdictional requirements are not satisfied, the action of the agency is a nullity. So if that agency, and we'll assume it's the IRS, doesn't prove they have jurisdiction, the action of the agency is a nullity. Okay? So it's real important for us to know that we hold their feet to the fire. You know, when you hold their feet to the fire, good things happen. Okay. It also says that the law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. That doesn't say go into court, does it? It says all administrative proceedings. They've got to prove that they've got jurisdiction at all times. All right? Now, let's go up a little higher, Ray, on this one. How important are implementing regulations? For federal tax purposes, federal regulations govern. Is that clear enough? Always, always, always look for the regs first and the law and the statute second. Because this is what governs, is the federal regs. Okay? Now this is opposite of the way we've all been doing it for years. And I was just as guilty as everybody else. You know, I was always looking at the statute and trying to figure out how in the world that applied to me when I knew it couldn't. And it's because I was looking at the wrong thing. Okay? Okay. Now I'm going to show you those recent cases I was telling you about. If I can find them. Oops, let's see. Let's turn this thing around. Maybe I can do it better. Oh, yes. Let's see here. Now let's look at this. Before we get to that, I'm going to show you guys this. This comes from the Congressional Research Service. I sent a letter, and you're going to find this letter in the book. And this letter was sent to all the congressmen in Florida. And it says, you know, I'm confused because I can't tell by looking at a law whether it applies to the exclusive jurisdictional area of Washington, D.C., the enclaves and the territories, or whether it applies to 50 states. Now, how can I tell just by reading the law where it applies to? Now, that's a fairly, you know, isn't that something I feel that they should answer? Well, I got one answer from all the congressmen in Florida, and that was the representative in my district, and he lied to me. And basically what he said was, well, at the end of it, it's got D.C. if it applies to D.C., and it's got public law, then it applies, you know, to the general public. I mean, to the 50 states. And that's not true, okay? But I just wanted to see what they'd say. And anyway, here's this guy here. He sent that same letter. A lot of people have sent that letter, by the way, and we've got a lot of different answers. I mean, just a whole lot of different answers. But anyway, when a congressman can't figure out how to do it, he sends it up here to the Congressional Research Service and let them do the research on it and give you you know, an answer. Okay, and he says, this is to respond to your request to explain how one can identify a law that has been passed under Congress's authority to legislate regarding the District of Columbia and a law that is passed under Congress's authority to legislate according to the 50 states. Okay, now the key sentence is right down here. If you can pull that up, Ray. He says, when Congress passes a law, there's no requirement under the Constitution that Congress identify the nature or source of its authority. Okay, so what he's really telling you is, we don't have to tell you, and we're not going to. And that's what he's saying. Okay? There's no requirement for them to tell you, and so they're not going to do it. And that's just exactly what he's saying. And then he goes on and on and on. You know, I mean, it's so funny. Now, one thing I've learned about lawyers, and I'm not trying to offend anybody here, but the one thing that I've learned about the way they write letters is they'll tell the truth in the first sentence, and then they'll deny it in every sentence on down from there. And that's the way they do it. And I mean, I see this consistently all the time. The truth will be in the very first sentence, and then after that they'll say, but, you know, and but, they're just going to try to rebut exactly what they told you on the first sentence. Okay, let's go on, and I'll find these cases for you. Okay, let's see, here we go. Now this case right here is that case I was telling you earlier about Robert Braun, and it's U.S. versus Gene Wilson is the official name of it. And this was, these guys were a bunch of abortionists in Milwaukee, Wisconsin, and they were blocking the entrance to abortion clinics. Okay, well, the feds have a law called the FACE law, and that law says you can't do that. But they did it anyway, and the federal marshals were standing right there. Okay, well, they went ahead and did it, and the federal marshals made no attempt to arrest them. And so the Milwaukee police came out, they arrested them. And then they handed them over to the feds, who then charged them with the FACE law. Well, 5 of these people, all except this guy here, they hired attorneys. And the attorneys plea bargained for them, and they all went to jail. Okay, well this guy, this guy right here, Robert Braun, he decided not to go that route. And so he represented himself, and with the help of the National Civil Liberties Legal Foundation out of Milwaukee, they did all of his paperwork, you know, all of his briefs. The only thing that he only argued one point, and that was not that he didn't do it, but that Congress has no legislative authority on state land. That was his argument. That was his whole argument. He did not argue anything else. Now, I talked to Gene Zimmerman, who is the head of the National Civil Liberties Legal Foundation, after I found out about this. He told me that he was there every day of the trial, and he said that the judge absolutely did not want to rule for Braun, that he tried his best to get him off on different tangents. Let's talk about something else. And Braun just stood there like a rock. This is the only argument. This is it, you know. And he had 600 court cases to back him up. The U.S. attorney had 1 in rebuttal. And then he had the 800-page document that was from 1956, which shows that the specific areas in each individual state where the feds have exclusive jurisdiction. Of course, all the rest of them, they do not. And so this was his documentation, which, again, the U.S. attorney could not rebut. So what finally happened was the judge was so determined not to rule for him that he just decided not to rule at all. Well, they hit him with a motion for a, what's it called? Writ of mandamus, yes. And when he did, the judge says, yeah, you're right. And so not only did Braun get off, but so did all these other people. They got out of jail too. Because if Congress has no legislative authority on state land, it applied to them just like it did to him. So they all got out. Okay? But again, this is just a recent case. There's many, many cases. You take that Kahn case, that's an old case. You know, the courts have consistently ruled that down through the years. Okay? Now the other case I'm going to show you is U.S. versus Lopez. A lot of you guys probably have already heard that case. This is a case where a 17-year-old schoolboy in San Antonio, Texas went to school with a gun, which is really pretty standard equipment in San Antonio. And they found out about it, and the Texas people came in and arrested him. That's the site on it, 115 Supreme Court, 1624. Okay. Anyway, they arrested him. They charged him with possession of a firearm. But the feds wanted to make a federal case, you might say, out of this guy with their gun-free school zone law. They have a gun-free school zone law. It was passed in 1990, I believe. So they wanted to make a case, you know, a test case out of this guy. So they got Texas to drop their charges, and then they charged him with this law. But this guy had a better than average attorney. Now, I don't know where this attorney came from, but he says, wait a minute, he says, that law has nothing to do with interstate commerce, so it can't apply here. Interstate commerce, you know? And he says, yeah. Well, you know what the judge did? The judge says, oh, yes, it does. He says, those schools are a business. And those, as a business, they affect interstate commerce, so it does apply, and yes, he's guilty. Okay? Well, they took it up to the Fifth Circuit, and the Fifth Circuit ruled that, can we look at this right down here? Yeah, right. Okay. Basically, what happened on April 26, 1995, you know, was that the Supreme Court upheld the appellate court decision, and it goes on to the next page, which basically says that if it doesn't have anything to do with interstate commerce, we have no police power in the state. That's what it means, okay? And so if it doesn't have something to do with interstate commerce, and as a matter of fact, we've been researching this thing ourselves. We can't find where they have any authority, police authority, to come into the state anyway. You know, I mean, they have the authority to ask the state, yes, to come in and do something on their behalf, but they don't have the authority to come right in on individual citizens whatsoever, that we have found anyway. If somebody's found anything different, I'd like to know about it, but we haven't found it.
You have to explain Waco to us then.
Yeah. Okay. Well, I'll let somebody else do that. Okay, now we're going to get to the MFR01 status. MFR01, this is what an individual master file looks like. That happens to be mine. It's a 1979. And as you can see, it's all coded. You know, and this really doesn't have anything to do with them trying to hide stuff from you, I don't think. I mean, it's really just basically for computer entry. But this is the code that you're looking for here. Okay, so when you get yours, and we'll show you how to get that, basically you just file a simple little Freedom of Information Act request to your regional office, at least that's where we file ours, to Atlanta, and to the disclosure officer there. Just tell him you want your individual master file specific for whatever years you want them for.
Office for what?
Huh?
Regional office or what?
Of the IRS. It's the regional office of the Internal Revenue Service. That's where we filed ours anyway. And we get them back in anywhere from 2 weeks to 30 days. Okay? And all you're really wanting to know, at least what we want to know, is, you know, what's my mail filing status? This is mail filing requirement. That's what that MFR stands for. And your 01 tells you specifically what status you have. Okay, now we're looking at your individual master filing requirement codes for the Form 1040, right? It goes from a 00, can you guys all see this? 00 to a 12. Most people are going to be from an 01. I've never seen a 00 on anybody. And they say, I haven't filed since 1978. I don't have one of those. You know, but I've never seen one of those on anybody's. They usually go from an 01 to an 05, so let's look at those. An 01 says return not required to be mailed or filed. Okay, 02 means you filed a 1040A or a 1040EZ. 03 says Form 1040 with Schedules A and B only. An 04 is A, B, D, E with the Form 1040, and a 5 is Form 1040 with A, B, D, E, C, and F. Okay? Now, as you can see, all these other ones here, Virgin Islands, Puerto Rico, account is inactive, Form 1040NR, etc. Most of these do not apply. You know, I very rarely ever see any of these. Okay? Usually you're from here to here. Okay? Now, to be, this is not telling you that you have to. There's nothing on here that says that you're required to file any of these, is it? What it says is this is what you filed for that year. All they're doing is putting that down on your file. This is what you filed that year. Okay? This one here, though, just says that a return is not required. See specifically. Now, the way you get this 01 status, you can get it in 1 year. If you filed last year, say, a 1040 with Schedules A and B, you're going to be an 03, aren't you? That's what they'll have you for that year, and that's what it should be. But if you want to be an 01 for this next year, what you do is you just file a straight 1040 with no business schedules, or else you file nothing. One of the two. And we have found, and this is, again, just based on our experience, we have found that they'll still list you as an 03. Okay? Even though you're not supposed to be listed as an 03. So what you have to do is you have to send them a copy of the Privacy Act, which says that you have a right to look at your records, to get a copy of your records, and to correct and amend any that are not right. Okay? You send that with them along with a little letter that we have, which says basically this is incorrect. You know, your 03 designation for that year is incorrect. I did not file a Form 1040 with Schedules A and B. So therefore, please correct your record and send me a copy when it's corrected. All right? Now they have two choices. They can either correct it, or they'll have to tell you why it is correct. Obviously, if you didn't file a 1040 with Schedules A and B, it can't be correct, right? No way. It'll have to go here, because there's nothing else for a straight 1040. So that's it. So, yes, go ahead.
For official use only.
You can get this, though. This is from the 6209 manual, and you can get this also under Freedom of Information Act. You'll have to pay about between $60 and $70 for it, but they will send it to you, and you will have this along with a whole bunch of other stuff that shows you how to decode a lot of the things that are in your individual master file. But this is the way that you become someone who's not required to file or mail a tax return. All right? So what do you do when you get this designation? Well, I can tell you what's going to happen. And then, again, this is from my own experience. What will happen is they're still going to send you a letter. It's called a CP 515 letter. It's a request for tax return. Okay? Now they're going to say, we didn't receive your tax return for last year. I don't know if any of you guys have ever seen this letter or not, but I'm going to show it to you. I used to get them. Okay? It says request for your tax return. Okay? Now if we can look right up here, Ray, on the corner. See, there's that 515 I was telling you about. They actually send you 4 letters. They'll send you this letter that says request for tax return. Then they send you a 516. Then they send you a 517. Then they send you a 518. This is before they ever sign an agency case, okay? Each one of them will be a little bit stronger in their language about, hey, we still haven't got it, you know, blah, blah, blah. And then the last one says, urgent, it's overdue, please contact us immediately, etc., okay? But they all have one thing in common, and that's this right here. Raise this up some, Ray, so we can see this, please. If you're not required to file, tell us why. Every single one of them have that. Now, why would they have that? It's because there's a designation in their own file, isn't it, that there are people that are not required to file. If you're not required to file, let us know. Right? They want to know. Because they don't want to keep bugging you if you're not required. Obviously, people are not required. Okay? So you tell them. Now, there's actually 2 ways you can handle this. If you're not, you know, we'll say that you haven't filed and you're not designated as an 01, and here they are sending you these letters. You can send them the letter from Michael White, which says that there's no requirement for filing an income tax return listed in the Federal Register. And you also send them a copy of the 601.702 regulation, which says that there is no, if there's an obligation to, and we don't publish it, then we can't adversely affect you. Okay? You send those two along with a cover letter stating, you asked why I wasn't required to file. Here's why. There's no obligation to do it published in the Federal Register. And if this, if there is, please send it to me, and I'll file.
What is notice 557?
I don't know. It's just this is one of those fluff things. It really doesn't mean anything as far as we're concerned. Because see, he says right here, if you believe you're not required to file. And then it says, if you're not required to file. So some people just believe they're not, and then some are not.
According to them, the notice 557 is we must file.
Huh? Mm-hmm.
It says that,
Well, I don't know. I've never read it, so I can't tell you. It really doesn't matter to me because I know I'm this, But there's no, see, you have to understand, nobody's required to file, right? Because there's no requirement. Now I'm talking about general public. General public. There are people who are required to file. People who live in Washington, D.C., the enclaves and the territories, absolutely, they're required to file. No ifs, ands, or buts about it. They're on federal territory, exclusive jurisdiction. The feds have every right to force you to file a return. Okay? What's that?
The gentleman asked if federal employees are required to file.
Well, that's, yeah. And on state land, I would say no. But on federal land, I would say yes. Now, that's, again, that's a guess because I really haven't looked into federal employees that much. I mean, most of the people that I've talked to and concerned about, are not federal employees. I just haven't looked into it that much. If I was a federal employee, I'd look into it more, I can guarantee you. Anyway, all of them say this. If you're not required to file, let us know why. Okay? So all you do is just give them those two documents. But the key to what we do here, if you're not an 01, is we say, give me the page in the Federal Register, and I'll file. Now, what have you done? You've just destroyed any willful intent on your part to do anything bad. Right?
You're trying to find the law that you're violating.
Where's the saying? We've just destroyed any willful intent to try to evade taxes, to try to avoid not paying taxes. Okay? Now, we put all the burden on them, haven't we? Now, you say I'm required? Prove it. Give me that page from the Federal Register. It's not there. Okay? So, that's the way we do it. It's just that simple. You don't have to face them in this instance. I have a lot of people who get, whew, I didn't want to go down and see those guys, And on this one, you don't have to. You just send them those two documents. Now, if you're an 01 designation, then you send them 3 documents, don't you? 1, 2, and then your MFR, designation for that year. And that's all there is to it. But once you get to be an 01 designation, you want to use it. Now, one thing that somebody was telling me, I think it was Ben Houck, I don't know if you guys know him or not, but he was up here at Rogers' trial, and he told me that when he was there, he was going to testify because he does decoding of these IMFs, and he was going to testify as an expert witness. And he said that at Rogers' trial, Roger used this MFR01 designation because that's what he was. And that the U.S. attorney says, no, that's not what it means. Okay? Well, what should he have done? Okay? He should have done the same thing Larry B. Kraft did in Lloyd Long's case. And that was, don't make a statement like that. Put the IRS expert witness on the stand and say, what does this mean? See? Now you got him in a box. Because Miss Jew, who was the expert witness in Lloyd Long's case, said, MFR means that he's not required to file a mail tax return. Well, what was he in trial for? Failure to file a tax return. Kind of.
You can't have it both ways.
No, not hardly. The only thing I tell people, I say the only thing Larry B. Kraft did wrong, and I know Larry, he and I go round and round about this stuff because he says what I do is wrong, and I say, well, Larry, I said, you're trying to defend people from going to jail. I'm trying to get them off my back right at the start. I'm on the offense, you're on the defense. We don't come up from the same way. And we agree to disagree. But anyway, The whole thing that Larry should have done, as far as I'm concerned, is as soon as Miss Jew admitted that he was not required to file a mail a tax return, is to ask for dismissal of the case. Because the case was willful failure to file. And she just admitted he wasn't required to do it by their own records. Why are we having a case? As a matter of fact, there should be criminal charges being drawn up while we speak, you know, as far as I'm concerned, because obviously that was a criminal act on their part. See? Yes, ma'am. Oh.
Has there been any success in having money returned that they've unlawfully taken from citizens?
The only time that we've ever had property returned, let me put it that way, is two instances. That's bankruptcy court, and that's also when we file criminal charges against them. You know, when they've taken some and then they give it back, because that makes it a moot issue. Okay, so then the U.S. attorney and the county attorneys don't have to prosecute.
But nothing as far as the past taxes that have been paid?
No, to me, the best way to go after that is just to file a commercial lien and have it adjudicated. To me, that's a better way, and that's just my personal feeling on it. Some people like to sue. You know, I just don't like sue because it takes too long. You know, I mean, they can drag that stuff out for years and years, and you're in their ballpark, you know. So for that reason, I just don't particularly like it myself, but whatever makes you feel good, you know. Let's see here.
How do you stop an employer from taking out income tax?
Yeah. Well, okay.
It talks about, as used in these rules, the following terms have the designated meanings. And they put in quotes, Act of Congress means any law locally applicable to and enforced in the District of Columbia, in the territory, or an insular possession. And there's no mention of state there. So you might want to keep these things in mind. They don't try and use all this against you, but if you look to some of the key definitions and get down to the meanings of words, sometimes you can find the truth there if you really want to find it.
Okay.
Hey, Eddie.
Yeah, just a minute. I want to bring up one thing I forgot to bring up earlier. What are you? Are you an individual or a person?
Natural person.
Okay, what are you? No, just individual or person? Which one are you?
Individual person. Which one are you talking about? Title 26 or definition?
You're getting smart. Okay, what you really are is a human being, aren't you? Okay, human being. Now, do you think that the government doesn't know how to define human being? Yes, they do. Matter of fact, the other day I got something from Title 15, which is Commerce and Trade. It's Section 17, and it says that the labor of a human being is not a commodity or an article of commerce. Okay? And that's why that the labor unions are exempt from antitrust. Okay? The labor of a human being is not an article of commerce or a commodity. Okay? So that got me to thinking, you know, I don't recall ever seeing human being in Title 26. Oh, yes, you will. One time. One time. Joe went and did a search on Title 26 to see how many times the word human being was there. It was there one time. And that had to do with taxing vaccines. And that was when they used the human being to vaccinate. And that's it. That's the only time in Title 26. And the reason is because Title 26 doesn't apply to human beings. It applies to persons, it applies to individuals, but what are they? When you look up the definition of individuals and persons, corporations, associations, partnerships, trusts, etc., right? That's what they are. And that's what this would apply to in the area in which they would have jurisdiction, but not to human beings. They understand what human beings are. The labor of a human being is not an article of commerce or not a commodity. It's not taxable, period. If you exchange your labor for $5 an hour or $5,000 an hour, you have not created a taxable event because it's not an article of commerce, is it? There's no gross receipts, there's no gross income, okay? But you won't find that in Title 26, that's in Title 15. Yes, sir?
Back to what the man was saying about that 3401 and 3402 where you got to declare your reason.
Mm-hmm.
So if you put down you're a human being and not a person or individual, that would work, no?
You might want to quote Title 15, Section 17. Yes, sir?
I don't know if you saw the movie Death and Taxes, the biography of Gordon Call.
No, I didn't.
What he did was he filed a form, and I believe it was called a 1088. Is there any such thing that you've heard of?
I haven't heard of it myself. Anybody else heard of it?
What?
1088 form?
I heard 7288 or something.
7288? I haven't heard of it.
Show me that joke one time.
No. Yes, sir.
Regarding the withdrawing of the large sum of $10,000, that's a specious argument, isn't it? Because the bank would be, the federal government would, is part of the bank system, okay? So they get your account number from the bank, okay? So they're gonna know it anyway.
Well, it really doesn't matter. What it's saying, though, is you can't be required to file it.
The participant is not required to file, only the financial institution.
Right, but
You can't go to jail for it, in other words. They can't force you to do it. See, and they throw people in jail for this every year. Every year. I know a lawyer in New York that, see, you know, that case, that California bankers case was 1974. And Oliver North's case was 1988. And this case was done like in 1990. This lawyer up in New York that I know, he had a restaurant owner that didn't want to fill out this form. And so he kept going into the bank and, you know, depositing and withdrawing, always in less than amounts. But in some days he would do more than $10,000. And, you know, and so they caught him and they convicted him because Richard did not know that the implementing regulations say that he's not required to do it. He spent 1 year and a day in jail for this, which absolutely, if Richard would have known that the implementing regulations say only the financial institutions required to do it, he would have never gone to trial. See, that's how simple it is. You can beat these things in a lot of ways, guys, and the best wins are when you don't have to go to court. You know, when you get it done before court. I mean, that's, to me, that's the best win. Yeah, go ahead. Yes. Yes, I have. I went, when I first got into this, I was following a couple of guys named Irwin Schiff and Marvin Cooley, and they were recommending at the time, this was back in the late 70s, to file Fifth Amendment tax returns. And I did, because I thought that was a good way to go. I mean, it sounded reasonable to me. I did it for 3 years, and then the IRS came in and found some third-party records and used that as a basis for convicting me of failure to file for 3 years. So I went to jail for 2.5 of those years. Yes, ma'am.
I read where the IRS is going to go very heavily into investigating bartering.
Mm-hmm.
I mean, they're really going to hit.
Right.
What's your idea on that?
Hey, they will certainly do it.
I mean, they're there to lie, cheat, and steal. I mean, you know, what else are you going to do, you know? I mean, as far as I'm concerned. Yes, sir.
That 6172, that must publish section, what was that? Is that in their regulations, IRS regulations?
6172.
That's 6172, where it says they must publish in the Federal Register.
Oh, that's Title 44, sections 1505, 6, and 7.
Oh, I know what you're talking about, the 601.702. Yes, that's their particular regulation on that, which says effective failure to publish. That's 601.702. Yes, sir.
When the court ruled, as they mentioned, about the labor not being commodity, it's because in 1863 in Butchers Union versus Crescent City, the United States Supreme Court already ruled that labor was property. And it goes like this. Labor is the most sacred and involved property. Now, being involved property, and there's a long quote on that, they are quoting from Adam Smith's Wealth of Nations, that it was the substance and the foundation from which all other property comes. Well, being property, that means if the federal government wishes to tax it, if they had the jurisdiction to tax it, it would have to be by a direct tax, needing a portion. And because the 16th Amendment said without a portion, you mentioned a Busheber, well, the other one is Stanton versus Baltic Mining, where it declared again that all the 16...
I think there is, and I got a form, and I don't even know if it's valid or not. Somebody sent me this form for withdrawal of your application. Have you got one of those?
I'm trying to get one.
Yeah, I've got one, and I'm going to send it in. It's a form 521, so you know I'll let you know how it turns out. Yeah, I mean, I'm going to fill this thing out and send it in, just see what they'll do.
Well, my understanding is if you sign up for Social Security, you become an employee of the federal government, giving them jurisdiction.
Well, that's what Joe found the other day. He was, hey Joe, where was that that federal personnel thing? Where did we find that? You know, yeah, remember the one you sent me where it said that if you are eligible for a benefit from the federal government, that you are classified as federal personnel.
We talked about, I think it was in Title 5, Section 552A. It describes, how was it described? Basically, it said anybody who is eligible to receive a retirement benefit under any program under the United States government is considered federal personnel.
Yeah.
So immediately in my mind came Social Security.
Sure. Absolutely.
But then I started thinking, well, you're only entitled to a benefit when you apply for a benefit. Up until that point, you're just giving money to them, and they're taking it. But until you apply for a benefit, then you'll discover whether or not you are entitled to a benefit.
So once you apply for Social Security, then you're a federal...
Well, they have you classified as a federal employee. Now, I wrote to the Congressional Research Service, or actually I wrote to the local congressman, and they sent it off to the Congressional Research Service, and they called me up about 2 or 3 times, wanting me to narrow down my questions, and basically they just didn't want to answer it. Then they sent me another publication instead, basically questions regarding the federal income tax. You know, they sort of had labeled me. But that's where it came in. 552 describes individual. It defines it as a citizen of the United States. To me, I boil things down. Well, what does a citizen mean? What does the United States mean? And if I look into Corpus Juris Secundum, where it talks about who is a citizen, it says that you must first, by birth, the citizen must be born within the territory of the United States and under its exclusive jurisdiction. That means under its obedience and so on. Well, I was never born in a territorial area of the United States, like a federal enclave or Indian reservation, who knows what. I was born within the geographical boundaries of the state of Pennsylvania, or actually the Commonwealth of Pennsylvania. And so I didn't consider myself a U.S. citizen in that sense. But I look into it a little deeper than average.
In section 301, 1905 of the Social Security Manual of their code, it says if a person no longer wishes to obtain the benefits, that they can terminate their agreement.
Well, maybe that 521 is a valid document then.
I sent a couple of
We'll
them,
see.
they just disappeared.
Oh, is that right? You did send them in?
Yeah, I tried to find out what happened to them, and they're just gone.
All right. Okay, yes, sir. We have 2 more, and we're going to close it out.
I just go to the IRS office.
His book in your head. If you don't have the knowledge, you have to rely on an attorney. You have to rely on an attorney. The attorney is hauled into chambers, and he is told, if I bring up any issues on constitutional law, I get a $10,000 sanction. I asked the attorney who defended that case, and he told me, the judge told him that if he brought up any argument, he would get a $10,000. Now the judge gets a bonus for every conviction. The prosecutor gets a bonus for every conviction. You hire the lawyer, he's going to do the best he can, but I'm going to here to tell you, he can't do better than you. So learn. Don't fool around. Go hit him on everything but the kitchen sink and beat him before it even goes to trial.
Carl, to add to that, Carl wasn't there when the jury went into deliberation, but while they were in deliberation, they came back and they wanted to get specific information on Roger Saad's personal testimony. And unfortunately, I don't think Roger Saad was prepared to go before the jury and the judge. And the judge cut him off a couple of times too. I know Art Morris wanted to meet with them the weekend before.
Unfortunately, he changed his real testimony that they were prepared to go on a good faith to the point that he didn't owe it. You don't change